Ladies and gentlemen, welcome back. Now we'll begin the last session of the conference. Session 5 will be conducted under the topic of cross-cutting issues, dispute settlement, and principles. His Excellency Lee Jae-hyung, Judge of the International Tribunal for the Law of the Sea, will moderate this session. And Judge Lee, now the floor is yours.
Let me first join previous speakers in expressing sincere thanks to the Ministry of Foreign Affairs of the Republic of Korea and the Korean Society of International Law for their hard work and warm hospitality. My appreciation also goes to President Hader on behalf of the ICLS as one of the co-organizers of this conference. We frequently use the expression last but not least, and that is exactly what I believe is applicable to this final session. At this session, we are going to focus on dispute settlement and principles. Putting a reliable and effective dispute settlement system in place is essential in ensuring implementation of and compliance with the provisions of any agreement. Furthermore, it is conducive to the development of relevant jurisprudence by international courts and tribunals through the interpretation and application of the agreement. The dispute settlement system in Part 9 relies heavily on Part 15 of the Convention, but also incorporates some elements from the Fishery Stocks Agreement. In addition, there are newly introduced provisions which limit the jurisdiction of a court or a tribunal in some categories of cases, which will be further elaborated on during the presentation. With regard to principles throughout the negotiations and across the board, divergent and sometimes conflicting views and approaches vis-à-vis the governance of BBNJ have served as stumbling blocks on the way forward. In this regard, it is a great feat that the negotiators finally came up with a compromise text. How was it possible? Is it solid enough? Aren't there loopholes? We have, just like the previous panels, a dream team of speakers and discussants with hands-on experience combined with impressive academic background. And our first speaker is Mr. Kurt Davis. Mr. Davis is Deputy Permanent Representative of Jamaica to the United Nations. And in his own bio, he introduces himself as a person who is passionate about communication. And it is indeed the case. Yeah, during the last days of the resumed fifth session, he made a very eloquent and moving speech and received a standing ovation. So I hope that we'll be able to get a glimpse of his passion while he shares his first-hand experience as a facilitator for Part 1 and Preamble. And it is no wonder that he once served as a speechwriter for the President of the United Nations General Assembly. Mr. Davis, the floor is yours.
Thank you very much, Judge Ree. Good afternoon to everyone. I'm very pleased to be here with you, and in that vein, I extend my thanks and appreciation to the organizers of the event, and of course to the Secretariat and the hardworking team of volunteers and staff members who have been doing all that they can to ensure that we are having a smooth and successful time. Thank you very much. I must say that I came into this process of the BBNJ, unlike many of my colleagues who have gone before me. I know of some who have said that they were there from the very start. I like to boast that I came in at the very end, so all the success was because I came in. But I used to hear of this BBNJ long sentence name many years ago while I served in a previous capacity at our UN office. And I would listen and kind of half tune them out because it was just, to me, a lot of technical details about marine resources which were not fish. And as far as I was concerned, there are other things in the sea. I didn't even think of that. And then, lo and behold, having come back to our mission to the UN, I was assigned the role of lead negotiator for CARICOM, Caribbean Community, on the cross-cutting issues, which I was at least very relieved when I was first told that you are doing cross-cutting issues, because these were just the threads that would tie the whole agreement together. But indeed, the troublesome areas would have been the MGRs, because that's all about the money that nobody wants to give up. And then it was going to be about the ABMTs, because that's the power on the sea and nobody wants to give up their sovereignty. And of course, the EIAs, which is the complete technical details, which ordinary people like us have no idea what they're talking about in that room. And so I felt I was going to have the very easy job until I discovered that the cross-cutting issues entailed a very deep discussion, long-standing divisions on a lot of the principles that underpin the agreement. And so it was interesting to me that, unlike their last panel, which concluded their session first, the section on the section on the cross-cutting issues was in fact the last thing finally agreed at the wee hours of the morning, when we tried to run back upstairs for those who were there in the basement to catch the last half hour. That was, a 2-hour half hour, if you remember. So the principles and the dispute settlement section of this agreement turn out to be very, very much at the heart of, I think, what underlies the divergences that come in on the approaches that surround the law of the sea, and certainly on this question of areas beyond national jurisdiction. We tend to find that the agreement is addressing and dealing with and pressured by conflicting principles and approaches. So it has different roles. On the one hand, there are some who push it as a conservation instrument, whereas there's others who are looking at it as a sustainable use instrument. And so we had to work to see how are we going to ensure that it's both all the time at the same time. There are opposite approaches. Of course, we know the long-held debate about freedom of the high seas, underpinned, of course, that the areas beyond national jurisdiction are owned by no one, and the opposite side, of course, that it's owned by everyone, being the common heritage of humankind. And then, of course, there are different preferences that came out during the negotiations. The strong global governance regime is one approach that some delegations preferred. They wanted a nice, robust global governance, whereas there were others who were, of course, more keen on a state-led approach. And we see this flowing right throughout the agreement in all the different parts and sections, on the MGRs, CBTMTs, ABMTs, EIAs. All of these two-part approaches come out. So we can note the distinction took place both in the advocacy phases as well as during the negotiation phase. And later in this presentation, I will look at how the agreement attempts to address the differences. And I'm sure we'll have a discussion about whether this was successfully done. As was said yesterday, we have a patchwork is the word used for the existing governance framework on the oceans. We know that UNCLOS is the overarching framework, the constitution of the ocean as we call it. But there are numerous other instruments and commitments and guides and policies related to maritime and ocean affairs. We know there's the IMO Convention and various other agreements under the auspices of the IMO, the Convention on Prevention of Marine Pollution, Safety of Maritime Navigation, quite a lot. There's even on ILO, labor conditions as well. And now we are moving into negotiations which are ongoing on marine litter and plastic pollution. If you come out of the legal realm, we also have the SDGs, which include SDG 14 with targets on IUU, acidification, etc. So we know that the ocean governance in areas beyond national jurisdiction is quite fragmented, as was said before. We have geographical distinctions, we have regional jurisdictions, we have thematic and issue-based structures, different RFMOs. Some elements of the work is on ocean science, some is on industry and shipping. I mean, nobody wants to talk about the naval and military element, but that is there as well. So there's a lot that is going on out there, and the BBNJ agreement is, of course, trying to address these various divergences. It's trying to maintain a balance. And this has been done in several ways under the cross-cutting sections, trying to maintain this particular balance. So one of the things that we did was to include clear language on the relationship between the BBNJ agreement and existing mechanisms, as you see in Article 5. This question of does not undermine is addressed there. We also have the inclusion of the without prejudice language in Article 6, addressing territorial claims. We have the listing of the general principles and approaches in Article 7. And there, of course, we managed miraculously, I'd say, to come to an agreement of how to reference in a very delicate way both the common heritage of mankind, humankind, and the freedom of the high seas in that particular section. So it reflects an attempt to accommodate the varied interests, harmonize different perspectives and positions, and to balance the two streams of the agreement's scope or aim. So we come to dispute settlement. With there being so many varying approaches and perspectives, multiple layers of regulation, and colliding political and economic interests, the likelihood of a dispute arising in the context of the new BBNJ, as far as I'm concerned, is real. Is conflict inevitable? I suspect that Judge Ree, yourself, and President Haider and your colleagues may become very busy in the time ahead as soon as this agreement really comes into force. And so we have the dispute settlement provisions that have been laid out. Articles 56 to 61 address the settlement of disputes under the BBNJ agreement. Article 56, 57, and 58 contain what might be considered as non-controversial provisions, which are normal and self-explanatory. In fact, some negotiators question the need to include them at all. Admittedly, there was a view that their inclusion might muddy the waters with respect to the intentions of the dispute settlement mechanisms to be pursued under the BBNJ if you had to respell them out. I've come to understand and learn in my time doing negotiations at the United Nations that nothing is actually non-controversial at the UN anymore. So they are fully included and referenced there. The obligation to settle disputes by peaceful means, the prevention of disputes, that parties have an obligation to prevent disputes, to cooperate to prevent disputes, and of course, settlement by any peaceful means chosen by the parties. We have also Article 59, which addresses disputes of a technical nature. And so it creates a kind of a carve-out just for technical disputes, a straightforward technical option, if you want to call it that, which would be an expert panel established by the parties to such a dispute. And the work of that panel would not be able to rely on the other procedures set out in the agreement. And the powers that such a body would have does appear to be open to determination by the parties that are establishing it. So that one is meant to create, for want of a better word, a quick solution to specifically technical only disputes or differences of views that parties may arise. When we come, however, to Article 60 is where we see the bulk of the broad dispute settlement procedures set out. And it gives the procedures that are available to parties who will sign on to the BBNJ. And it is noted, though, that these are, in essence, replicated from Part 15 of the UNCLOS and made applicable to non-parties to UNCLOS who become parties to the BBNJ. In the layout, however, it made a special distinction between parties to the BBNJ that are also parties to the UNCLOS and parties to the BBNJ that are not parties to the UNCLOS. And one may ask the question, what is the intention behind that specified distinction? So the procedures that it has set out, for example, are laid out where a party who is party to both the BBNJ and the UNCLOS will automatically have the same settlement option from UNCLOS applied to it for the BBNJ, unless an alternative is chosen at the time of joining the BBNJ or at some point thereafter. This is expected to be the most common occurrence since the number of UNCLOS parties is high. So parties who then join in to the BBNJ will automatically have their UNCLOS settlement unless they say otherwise. But if you are a party to the BBNJ but not a party to UNCLOS, then you would have to select from the menu of options in paragraph 5. And we note, of course, that these options in paragraph 5, the ICLS, the ICJ, an Annex 7 tribunal or an Annex 8 special tribunal, are identical to those in UNCLOS Part 5. That would be in Article 287. So a question that arises then is whether these BBNJ dispute settlement procedures are compulsory and binding for non-UNCLOS parties. So, I looked at just how it was worded. UNCLOS experts, of course, will know that in Article 286, Section 2 is specifically named compulsory procedures entailing binding decisions. Whereas in the BBNJ, it does not make such a specific indication. A question can therefore be asked, was that purposeful? BBNJ's Article 60, Paragraph 1 and Paragraph 2 make Section 15 of the UNCLOS applicable in totality. That's what it says. So does that include the compulsory binding nature of dispute resolution options? Or was it purposeful in restating the relevant provisions, which were spelled out in totality again in the BBNJ agreement? So it's one of these possibly, for want of a better word, purposeful, I think, I don't even know if I should call it an ambiguity. I think it was purposefully done as somewhat of an appeasement and an inducement to give comfort to all parties or all states to become parties to the BBNJ, given in particular that there are a lot of sensitivities surrounding the UNCLOS itself for non-parties to UNCLOS, and also the issues surrounding sovereignty and the compulsory nature of decision-making or dispute settlement in the BBNJ agreement. You know, these were challenging negotiations from start to finish. And the attempted balance in the agreement may not hold for a long time. You'll see in this shot, apart from the very happy moments of gaveling, a lot of huddling you'll see in corners here. And I think that the dynamics of the negotiation may foretell that the different approaches and interests have not been abated. We managed to come to a consensus. We managed to adopt the agreement. But I do get the sense that the strongly held positions of different countries did not move along. I don't know if any of my fellow negotiators and observers who were there would corroborate that observation. There were other pressures, I believe, that pushed us along and compelled us along to get this agreement adopted and to put the best possible language in it. However, given those dynamics and the strongly held views on the positions, the approaches, and the perspectives on the high seas, areas beyond national jurisdiction, I get a sense that we may have a lot of remaining differences that when implementation time comes, we might find, the need for the settlement of disputes. We also note, of course, as was said earlier, that the negotiations also left a lot of matters to be resolved by the COP, especially the first conference of parties. I know many of us joked that that first conference of parties seems like it's going to be a month-long meeting because it has a lot of work that it needs to do at that first conference. It does look to me that there will be ample room for disputes. So, while the BBNJ negotiations and the agreement did not magically resolve these long-standing divergences, the agreement seeks to balance the opposing views and approaches, and I'm sure we can have a good discussion as the panel goes on over whether this balance is satisfactory and whether it will actually be able to hold. It provides all the parties with wide-ranging options to settle disputes that may arise. And I'll throw my view out there from now, because despite whatever flaws it may have, I still do believe that ocean governance would actually be significantly bolstered by the new agreement when it comes into force. And an early entry into force will also be a major leap forward in attaining our shared objective for the conservation and sustainable use of the high seas and the marine biodiversity of these areas beyond national jurisdiction. Thank you so much for your attention. I look forward to the vibrant discussion which I'm sure will ensue from here.
Thank you very much, Mr. Scott Davis, for very concise and overall review of major principles and dispute settlement system.